Good evening. For those of you who don't know me, I'm Joan Wexler, the Dean of Brooklyn Law School. I'm delighted to welcome you to our second Barry Zaretsky Roundtable. As I think many of you know, Brooklyn Law School lost a dear member of its family when Professor Barry Zaretsky was killed in a tragic accident. Barry personified all that it means to be a great teacher, scholar, and lawyer. And he left an indelible mark on Brooklyn Law School as well as on the legal profession. Barry joined our family in 1983. He taught sales and secured transactions, debtor-creditor law, commercial paper, torts, and a few other courses, but bankruptcy and commercial law were his real domain. He wrote many cutting-edge articles in those areas, and his work appeared in leading law reviews and treatises. His New York Law Journal column was read avidly by practitioners. Most important, Barry was a wonderful mentor and teacher who took his responsibilities and his students' concerns, but not himself, very seriously. Next year, the bankruptcy section of the Association of American Law Schools will be dedicating its program on teaching bankruptcy law to Barry and Vern countrymen. Barry was a beloved colleague, a respected teacher, and a great friend. Over the years he was with us, he touched literally thousands of lives, and some of his students are here this evening. And as much as we miss his presence, we still feel it. And for that reason, today, we convene this roundtable in his honor. I want to thank all of you for joining us tonight. Your presence is a tribute to Barry and also to our roundtable steering committee, our distinguished graduates, Herb Edelman, Neil Berger, Jonathan Flaxer, Andrew Goldman, Scott Hazen, Lawrence Gottesman, Angela Teasy Milner, Joseph Zamet, Robert Schmidt, Paul Silverstein, and Richard Stern. Larry Gottesman's partners, Jeffrey Weingart and Kenneth Adler. Myron, did I miss you? Yes, and Myron Trepper, I'm sorry.
It's okay, you can miss me.
No.
Most of the people are trying to do
Jeffrey Weingart and Ken Adler are here to help us understand some of the business models that we'll be thinking about tonight. They are the co-authors of the books Doing Business on the Internet, Forms of Analysis, and Intellectual Property Licensing, which will be published by the Law Journal Press, which was published in 1999. And they'll be aided by our adjunct professor, Sylvia Kacharian, who is the Technologies Group Counsel at American Express. She's actually teaching tonight until 8, so she'll be coming up in a little while. And Professor Paul Schwartz, who's here, who is one of the world's experts on e-law and internet privacy law. I also want to thank Robert Grossman, Judge Jeffrey Gallant, Larry Gottesman, and in particular, the professors on this faculty, Neil Cohn, Ted Jank, and Michael Gerber, for organizing tonight's program, for agonizing over the materials that you all have before you. A tremendous amount of work went into this production. And a thank you to Diane Odone and June Seto, our senior administrators and their staff, for making sure that everything works flawlessly. Finally, let me introduce Heike Vogel and Bennett Silverberg, who are this year's recipients of the Barry L. Zaretsky Fellowship. And I ask our students to just stand or wave their hands. These Fellowship provides support to students who have demonstrated outstanding academic achievement in the fields of commercial or bankruptcy law, and a commitment to working with faculty members and graduates in connection with law school programs in honor of Professor Zaretsky. Both Heike and Bennett will be graduating this year. Next year, Bennett will be an associate at Skadden, and Heike will be clerking for our very own Judge Gallup. Now, let me introduce Michael Gerber, whom I'm sure all of you know will get our program underway. Thank you.
Good evening. It's a pleasure to see you all here, even as we remember a good friend who isn't. Thinking about Barry, especially in the context of tonight's program, I'm reminded of something that happened more than a decade ago. On the morning of Tuesday, October 20th, 1987, Brooklyn Law School Center for the Study of International Business Law held the first of its now venerable stock exchange breakfasts. Now, some of you will remember that October 20th, 1987 was the morning after the crash of 87, when the market took a nasty 508-point fall. Now, it so happens that Barry and I went to the breakfast together, and we were standing in line at the exchange's VIP entrance, awaiting security clearance, when we were swarmed by reporters. "Where are you going?" they wanted to know. "To a meeting," I said. "Where?" one of them demanded. "In the boardroom," I said. "So, who are you guys?" Another one asked, and I said, "Look, we're just a couple of law professors." And one of them pressed a mic in Barry's face and said, "What do you teach?" Of course, we could never be sure, but Barry and I always felt kind of responsible for wiping out at least several margin accounts. Because of what happened on October 20th, 1987, I want everyone here to know that when we met last fall to pick the topic of tonight's program, we had no reason to know how timely our choice would turn out to be. Think about it. 2 weeks ago, Newsweek reported that, according to Merrill Lynch senior analyst Henry Blodgett, three-fourths of today's dot-com companies would be bankrupt within 5 years. Business Week's April 7th, that's this week, April 17th cover story is entitled "The Dot-Coms Are Falling." Of the 272 internet IPOs during the past year, 88 are now trading below their offering price. As capital flees from new chips to blue chips, cash-starved dot-coms are having to scrounge for cash if they can borrow it, and many of them won't be able to. And some analysts say that according to recent SEC filings, a number of well-known e-companies are on the brink. Well, what does all of this mean for insolvency lawyers? And what does it mean for those who do business as or with dot companies and the lawyers who represent them? Many dot-coms have few hard assets, but they do have soft assets, including intellectual property, copyrights, patents, customer data, even ideas that have substantial value. Doesn't that make them fit risk for the bankruptcy mill? If and when dot-coms fail, will they just fade away, or will they file? Business Week says that dot-coms are falling. Can Chapter 11 help put the pieces back together again? If not, can Chapter 7 help us wring the maximum value out of the shattered pieces? Is bankruptcy an option best left unexercised? Those are some of the questions that we'll be pondering tonight. And in a moment, Professor Jenner, who's sitting over there, will set up our hypothetical, and Judge Gallup will open the discussion and moderate it. For those of you who didn't attend last year's programs, I want to tell you that the Zaretsky Roundtable is not intended to be a panel discussion. You all get to talk if you want to. If you don't want to, you don't have to, but you're welcome to. And if you do, slide a mic near you. And for those of you who are sitting in areas where there are no mics, I'll be wandering around with a wireless one so that you can speak too. The reason that we couldn't mic everyone is because there are about twice as many of you as we expected to see tonight, but we wanted to try to preserve the roundtable format as best we could and not turn anyone away. I'll close, but I'll leave you with a question. One more thing I want to do. There would be 300 guests right here if Judge Stan Bernstein were not apparently caught in traffic. But we have two, Judge Gonzalez and the newest addition to the Eastern District Bench, Judge Carly Craig, who was just formally installed on Thursday. So let me just leave you with a question and a couple of thoughts. And the question is, what's a .com worth? This may be the last issue that we talk about tonight. And it's an issue that's likely to be litigated in e-reorganization cases. Now, according to a Fortune magazine article that appeared last January, based on their then market caps, AOL is worth more than GM, Ford, and the entire American steel industry combined. Yahoo, which is not to be confused with Yahoo, the company that we'll be talking about tonight, is worth more than all of America's railroads combined. Amazon.com is worth more than Sears, Kmart, JCPenney, Saks, and Neiman Marcus combined. And eBay is worth about the same as the New York Times, Dow Jones, and the Washington Post companies combined. Now, bankruptcy lawyers are fond of pointing out that figuring out the going concern value of any firm is a guess compounded by an estimate. But how do you determine the value of an internet company that has few tangible assets, scant earnings, if any, and a future that can't be reliably predicted? Well, here's Warren Buffett's answer. If I were a business school finance professor, he said, I'd assign the following exam. How do you value internet companies? And I would fail everyone that did not leave the answer sheet blank. Ted.
Well, what would a program on .com bankruptcies be without fancy audiovisual aids? I've been joking that my role tonight is to serve as the AV crew, and that really is it. I'm going to present the hypothetical and then hopefully fade into the background. What I'd like to do is introduce a company, and with it, the internet business model. Yahoo Incorporated is a Delaware corporation that operates two internet-related businesses, Yahoo.com and Yahoo New Media. Yahoo.com is a company that sells traditional and alternative cold remedies over the web, while Yahoo New Media is a company which provides internet-related services to companies that want to do business over the web but don't have the facility to do so in-house. Among the specific services that Yahoo New Media provides are building and maintaining websites, receiving orders over the web and communicating with customers regarding web transactions, processing credit card payments, filling orders, and processing and analyzing transaction and customer-related data. Thus, a web surfer who orders bath towels online from Bed Bath & Bygone is actually looking at a website which was designed and is probably being maintained by Yahoo. Thus, Yahoo.com operates in what is known in the industry as a B2C or business-to-consumer mode, while Yahoo New Media operates in what is known as a business-to-business mode. Now, Yahoo has a lot of old-style assets. It operates its business out of offices on West 21st Street, but it also has significant old property, including inventory, office furniture, computer servers, and other hardware necessary for developing and maintaining websites. But they also, in addition to the old assets, which, by the way, we're not going to talk about anymore this evening, it has a lot of new economy assets, such as the Yahoo.com domain name and trademark, intellectual property interests in content and graphics, licensing. It's also a licensee and licensor of software. Now, let's take a moment and talk about the structure of its rights as a licensee and licensor of software, because those rights are likely to loom large in any internet bankruptcy. One piece of software that Yahoo uses is called WebPay, which it uses to provide secure credit card payment processing services to its customers. In addition to licensing WebPay from WebPay, Yahoo's master license also permits Yahoo to embed the software in its own web builder software package, which it in turn licenses to its customers. The master license prohibits any transfer, assignment, or pledge of the assets, and doing so constitutes an event of default which will terminate the license. Thus, Yahoo derives its revenue from two sources: from the sale of goods and advertising from the Yahoo.com site, and the income that it generates from the web hosting, design, and maintenance services that its new media division provides to its clients. Visitors to the Yahoo site are also invited to provide personal medical information so that they can receive customized supplement plans according to their particular needs. Now, this information is used to generate sales trend, price sensitivity, and other data, which is one of Yahoo's most valuable assets. Many other companies would pay dearly for it. However, Yahoo's posted privacy policy states in unequivocal terms, and actually I'll show you how it does it. Your personal information will never be shared with any advertisers or any other parties. We mean it, we mean it, we mean it.
Ted, while you're up there, could you show us some of the linking arrangements?
Yeah. Okay. Let's take a look while we've got the site up at the site. It's got a little bit of advertising, but when you click on some of the things that you might want to purchase, for example, oops. This may be a problem. Yeah.
You've all got the slides in the book.
No, not this. It's not going to work. I've tried this before. When this happens, it doesn't come back unless I turn the computer off. It's a problem with the network.
Hence the problem.
Hence the problem with the company. But what is a linking agreement? If we had, in fact, found our way to another site.
A linking agreement would typically involve an arrangement where there were goods or services advertised on one side on the partner's site. Typically, Party A and Party B may have content that would enhance or embellish the sales activities or business of the other, and typically they would cross-license content or services to one another, and there may be royalty streams that are generated through the sale of products. There might also be advertising, sharing of advertising revenues that are generated through the sites. One site may become more of a toll taker, and on the internet, pretty much sites can link to one another. We like to think that there's an applied license to link from one site to another, although there have been cases that have come out, one quite recently actually, on deep linking, what's called deep linking. But in a cross-licensing or co-branding arrangement, there's actually license agreements back and forth that allow linking, and maybe even deep linking, which means linking from to a spot other than, for instance, on the home page, but deeper into the site.
Okay. So, sorry about the video, but here's how Yahoo is set up. Here's their capital structure. Yahoo was founded several years ago by Max Hetkold, and initially financed by a group of venture capital investors, including Sign Us Up partners. After burning through several rounds of venture capital financing, and after it began to show a revenue stream, Yachu sold $25 million in bonds secured by all of its assets. And Yachu also has a number of trade creditors. No, we're going forward in time so that the dot-coms that don't have creditors now have actually gotten some before they file. Yachu's hosting and outsourcing operations have been profitable. However, sales from the Yachu.com website fell short of projections last year because, at the height of the flu season, a computer virus caused the web-based software to malfunction and the website to crash. As a result, Yachu lost customers and market share. Yachu management has realized that it will soon miss a payment to bondholders, and they're wondering whether the company should file a Chapter 11 petition. I now fade into the background with one question. Who are the likely sources of debtor-in-possession financing?
Well, Mr. Head Cold's lawyer goes first. What are you going to do with this company?
Well, let's start with what we're trying to figure out here. Max Head Cold, who started this company and has slowly given up pieces of it to a variety of people, has now convened a meeting of his esteemed counsels, and we are all trying to figure out, bond counsel is there, and the purpose of this is anybody can take any side of this you want. So whatever you feel comfortable being here, whatever role you want, if you want to play creditor, debtor, committee, whatever it is, that's how this is set up. So the purpose now of this meeting, we're all in the meetings where we've been, is my client, who's the principal of the company, has said to me, should I file? Now remember, my goal is to keep the company. It's going to be great. It's going to be worth a lot of money. Don't let the vultures get it. Somebody is bond counsel's company. Somebody also represents Sign Us Up. So what we're asking then is a Chapter 11, in the context of this company, something that is viable? Max wants to know if he can use the cash going forward. The bondholders argue that he can't, and that's where we throw it open. So looking for somebody who either wants to represent the bondholders. So which of our counsel here is used to standing up at a meeting and saying, I don't have to answer anybody as a secured creditor and you will go home? Who wants that role?
Ed, that sounds like you.
I only came down to find out which judge can authorize the sale of the customer data. But I think the first question as you raised is Chapter 11 is a liability.
Use the mic.
It's purposely turned off. I don't know how to turn it on.
It's on, we don't get away that easily.
But where does the financing come from? If Chapter 11 is viable, we need financing, and therefore I would propose that the bondholders put up some more money, or that the equity holders put up some money, and see whether we can get at least operating capital to move the company forward in the business sense.
Is there anything here to secure?
The assets, we just heard about the value of .com assets. Whatever the assets are, we can either provide collateral to a new lender by partnering the existing lenders with the permission of the court, or ask the existing bondholders who hold the security to protect their interests by putting in some more money. Obviously, somebody is going to have to demonstrate that the company is viable and has a future.
I'll just say there are significant assets, and typically in a hosting company like this, some of the most well heard of names right now, some of the .coms we're talking about, for example, Exodus Communications, Digex, for example, these are high flyers in the current market. The word on the street is that those companies cannot build facilities quickly enough to provide enough hosting operations and have data centers all over the world. So there are significant assets in terms of server hardware, facilities, related software operating environments.
Problem is, of course, that the bondholders have a lien on everything that's lienable. In this case, when they came in with the money, they took the normal clause of everything you have, everything you'll ever get, and your firstborn. So Andy, you represent the venture capital here. Looks like it's going down the drain. What do you do with it?
I offered to put in some more money, but I'm not going to be an idiot and put it in on an equity basis this time. I'm going to want to first lien, and I'm going to want to prime the bondholders. And if I'm greedy, I'm going to want releases on day one for anything that anybody may accuse me of ever having done.
But I know when you come to me, you'll have a second choice.
Perhaps.
On day one. What's interesting about this case is that this case probably stands or falls on day one. And the people around the table at Bob's meeting are the ones who decide what's going to happen at day one. As a practical matter, the unsecured creditors are not players here, right, Scott?
All the defects in the liens held by the bondholders should make the unsecured creditors players. Because how do they perfect their interests in the collateral they claim?
What are the defects?
Where do they perfect their interest in the site, the website?
You got to hold the microphone closer.
Where do they, is it on? Where do they perfect, or how do they perfect their interest in the intellectual property of this company? That is not a clear answer as a matter of law, and so we will find some confusion and some soft spot and challenge the lien asserted by the bondholders. Why are we going in Chapter 11, by the way? Is there a way we can keep this out of court? What do we expect to obtain through the Chapter 11 process?
The automatic stay.
What are we staying?
You're staying a web pay from terminating your operation by saying you haven't paid your license, you're down the drain. Once they end your license,
That is soluble by payment of money. So the question is, if there's a way to keep the business afloat with some new cash, there really probably isn't the need to go into Chapter 11. It seems to me Chapter 11, in this case, is probably a last resort, not a first resort.
It's all a function of value. Value is only issue. What's the work?
well, it's not only an issue of what it's worth, it's an issue of who's got it. The problem
is that he needs to use the bondholders' cash flow. By the time he figures out that it's challenge the lien, the company's going to be out of cash. Unless some judge affords an opportunity to operate on the bondholders' value. His threat to challenge the perfection of the bondholders will all day one of the bondholders. The bondholders are only allowed to buy them or lend money themselves if the unsecured creditors give up their challenge.
Myron, if you represent the bondholders here, what do you do?
Well, first of all, tell me, are these original holders in these bonds?
You know what I thought was going on?
I'm sitting next to somebody who has a penchant for acquiring securities in a distressed marketplace. If you have original holders of these bonds, they have a vested interest in trying to make this work and work under all circumstances. If you have someone who bought these bonds, and I don't know that they're traded, if you have someone who bought these bonds that's, perhaps based upon what I've heard, where nobody understands these businesses and nobody understands the values and everybody wants to get their hell out before they get into deep trouble at less than 50 cents on the dollar, then if my clients are secondary buyers primarily, they have a whole different perspective on what's going to happen. They may be willing to take a risk and fight with those unsecureds over the value of the assets. They may be willing to put up new money, but on very onerous conditions for a quick deal. But I need to understand whether my clients are the original holders of the private.
Let's make it hard. You're the original holders.
If you're the original holders, then you should want to follow Mr. Edelman's follow Mr. Edelman's view of the world, that you ought to try to stay out of bankruptcy before all of these people start picking at every legal issue while the business goes down the tubes as quickly as possible. So these businesses, at least to me, and I guess pointed out to me, one of the oldest people.
The oldest, you said.
One. I understand much less about these businesses, the technology, the words and phrases that have been used around this table, and it's sort of roll off the tongues of everybody who has a generation probably, ahead of us. So we're trying to figure out.
Probably 2 generations ahead of us.
Yeah, well, 3 maybe. I mean, at this point in time, nobody understands what financial distress means to these businesses. And you don't want your $25 million to be the laboratory in which you make a determination about whether Chapter 11 works or not, unless you're prepared to lose the $25 million real quick.
Don't you have to go into Chapter 11 here because you have to do something to find out who has a lien on what? If you don't go into Chapter 11, all the risks remain. If you go into Chapter 11, presumably you get a ruling from Judge Craig as to who really has a lien on what to do with cash collateral. Maybe you roll it up if you come in with more money.
I sort of view it as a matter of economics. If I have $25 million invested in this company and I see it dissolving before my eyes, I come up with a program. I go to the various parties who have control over these assets, at least in a meltdown environment, make them an offer that should work if I can convince my clients to put up new money, even if it's in the form of DIP financing, and condition it on having a deal that is done through the bankruptcy court and out within 60 or 90 days, because nobody knows what happens to these businesses in a proceeding.
Myron, we're in New York, we're not in Delaware.
Well, I don't care where we are, we're making new law here. This is groundbreaking stuff.
So you really have to leverage the bankruptcy judge. I mean, the only saleable asset here is the privacy of information. As far as I'm concerned, I'll lend you money, whether I'm a par player or I'm a bond player. If and only if I get a ruling from the bankruptcy court that the asset is saleable. There may be all sorts of claims and causes of action against our company as a consequence of them breaching their promise not to release the information. But what do I care?
Right, so this case really goes in the first month, and what happens on the first day sets it up.
And by the way, I don't know if his client or whoever the genius was that formed this company has any play, any role in it. We don't have the money. You can tell me how stupid is it? He got the money. The question is, do we need him? Does my client need him and any of his unique skills in the process of reorganizing this business, or do I go out and find the next genius and say, I've got the solution, Judge, I've got new management, I've got a financing package, I've got the deal. Now, we just can't sit here and wait 60 or 90 or 120 days while Hazen, tries to figure out where this...
Well, Hazen is filing adversary proceedings one a day.
That's fine.
Let's assume for a moment that you bring that issue up, and Max is now threatened with going back to the street and having to lose his Long Island mansions, and then says, what's in my best interest?
That's why he's got you.
That's right. So now what we're trying to figure out is, let's assume for the moment that maybe we can't reach a consensual agreement, and he's got somebody that wants to put up money, but the licensors now come in and say, the company is worth very little without our licenses, and we want to pull the licenses and terminate them because there's another company we want to use the licenses. You won't lend money, nobody will lend money unless we get a ruling that these licenses are either assumable, they're assets, they're something. How do we go through this analysis?
Well, let's go back. Let me ask you a question, Joe. You represent WebPay, and WebPay has this license that says if your file is vaporized, the way you do that is that there's some warehouse, someplace in North Dakota, you push a button and everybody's software stops. What's your position?
My position is that I'd like to, in effect, terminate and have everything vaporized, but I'm faced with an automatic stay problem. And that if I take certain action, I might be held in contempt of court, violate the stay, and the business is out of business, and I might be liable.
John, your license, your software automatically ceases to operate if the fees aren't paid, it's embedded in the software unless you keep turning it on, so you're not going to affirmatively do anything. You're just not going to do anything. It's going to go away, violating the automatic stay.
Yeah, but Scott, that's why you apply the order show cause along with your ad service.
I'm allowed to take conflicting views during the course of this program. I'm sorry.
We've actually got two different versions of the software. One where he has to send the signal to turn the software off, and another version where he has to send the signal to keep the software on.
To the extent that I have to take affirmative action, I'm staying by the automatic stay. To the extent that there is an issue here as to if I do nothing and it just goes, take my chances.
But would you take a chance, Joe? I'm curious.
Well, part of the question here is the value of this business generally. I mean, with all the people, with all the talent around the table at the hourly rates that are here, the numbers aren't high enough. So for $25 million worth of bonds, the people around this table are not going to be at this case.
Make it 250.
Well, if you make it 250, then you have a real case, but you also have, you work at and need to analyze what the value is of this business for the prospects.
They got a whole bunch of venture capital in here too.
That's right, you've got equity interest.
A lot of equity, and it's outside of the company.
Step back for 1 second, I'm curious,
Outside of management.
whether the Judge Craig and Judge Gonzalez' view, if a non-action by a party, something you probably never thought about, does nothing and it causes damage to the estate, could that be viewed as a violation of the statute? Judge Craig is learning when she's long.
We'll both answer, one of us will have a mic.
In other words, can you require them to do something to keep the software going and upon pain of violating the automatic stay?
What the judge needs to understand is that one of the people who developed the software used to be a bankruptcy lawyer and decided instead that they would develop the software. Knew about the automatic stay problem and designed the software specifically so that it would dissolve.
It strikes me as a violation of the automatic stay if the software terminates on filing, whether or not that's embedded in the software or whether they can do
It's
something.
terminating on failure to pay. It's not terminating on violation, right? It's terminating on a failure. It depends on what floor you're on in our building.
Let's make it a little bit more difficult, since that was the easy one. Make it a little more difficult. It terminates every month on the 30th of the month, unless Bob Schmidt goes out and tells his client to push the button. So you have the dual problem. Here, the goods are already with the debtor. So it may not be purely a situation of can you order them to deliver, but assuming there's adequate protection, can you order them on the first of the month to push the button?
Under what theory? The automatic stay theory?
Yeah.
I don't know.
No, under 105.
No, we should all be on the first floor. No, I don't think you do it on the automatic stay. I think you may come up with some other form of injunction to get it done, but I don't think it's the automatic stay.
I think in a case like this, an important issue that you're also going to have to face very early on is that the value in these companies very often resides in the heads of those young folks who work there in torn jeans, and if they start to head for the exits, you're finished. So you may have to come up with some very creative way very fast to keep all that talent in place.
But in connection with turning off the software, it seems to me that you're not going to be looking at the automatic stay. You're going to be looking at, somebody said it, an order to show cause on very short notice, and you're going to have a hearing to determine the impact of that action or non-action on the viability of the 11. And if you find in the initial phase of the 11, at the threshold, that turning off or turning or pushing the button is going to impact the business so drastically, it seems to me that a reasonable court is going to grant at least some temporary relief to see what's going to happen. And if it's a month by month, that's probably what you would be doing, not under...
So there's your first day order, the big one, right? There's the big first day order.
Well, I don't think it's a first day order, because you're going to have some notice. You're going to have to bring the licensor in, and you're going to have a hearing.
Hold on a second, there's some missing things.
On the hypothetical.
No, you're
There's not,
Are we going to propose to pay going forward?
You got to propose to pay.
Okay, so assuming you propose to pay going forward, why is it a lot different than the utility house? Why is it
It's not a lot different
not?
than the statute.
Why is it not, the right to use the property is property these days. The right to use this is property these days. You're going to pay for the right to use the property. And if utilities, Congress thought utilities can't turn off services or pay.
You know, whatever, but that's a limited access.
I'm not sure I disagree with you.
But I don't think you have to jump too far in the first step.
Myron, the problem you're going to have with the licensor is the licensor is going to say the debtor in possession can't assume the license.
I'm not.
What are you going to do?
Right now, I'm just paying.
I know, but
He's going to pay his $8 million.
I understand, but the licensor is going to say you can't assume it, you can't sell it. So what are you going to do with it?
So how many judges have you said, we'll get to that later? I mean,
Also, the reality, there's a technology reality, which is, when we advise our clients, I mean, most software vendors won't just turn off, won't flip the switch. They won't do it because of the risk, and non-bankruptcy risk. Just for a pure question, these companies have, short lives, especially when there's a market where there's a decline in financial problems. To flip the switch, and they could really be completely gone with no assets, nothing. Whatever continuing business is ongoing drops even precipitously very quickly. So we would never advise a vendor to shut the switch, or even, we're talking about a positive action by someone flipping the switch. The software is designed to continue operations. The software itself, not by inaction, but by action by someone programming it, may flip the switch. So we're talking about inaction, but there can be computer action we're not talking about, which can actually need to be positive action here.
Let me move on, although we could easily go most of the rest of the night on this. Let me ask you the other question, and Herb brought it up at the beginning, which is, among your assets is this database. In the new economy, databases are worth more than gold. What about this never database?
So, like I said before, I mean, if I were to lend to the company, I'd want to ruling court as part of the first day order or this day order.
Who do you give notice to?
And you give notice to people who are likely to complain, which is people who provide the data, which means all you have to give
By email?
delegation notice.
Publication or email?
Or email.
Remember, they all got to left their email addresses.
But what breach?
Ed, what ruling did you ask?
I'm going to ask the court to determine that the property is saleable. Yeah, we give rise to a pre-petition claim because you breached an agreement that you entered into with everyone providing data on a pre-petition basis.
You could post a notice on the site too that says it allows anyone who's done business to the site to go ahead and opt out of this. So that
A notice wouldn't be enough.
What do you actually sound like? How do you view this asset? You view it as a series of contracts with people that have agreed to let you use their data?
But I think the data is already in your possession. It's part of your memory base. The problem is you promised never to use it or exploit it. Now your lender's coming in and saying you need more money to run.
Hold on a minute, there are two separate questions. One question is, maybe I want to sell it to somebody else who's in this business. The other one is, maybe I want somebody to acquire me with the database. There's some interesting cases about the difference between of selling the assets and selling the stock. So is the way around it really to sell the stock so you don't have that risk at all?
If you could do it quickly.
But Judge, I think that somewhat begs the question as to who actually owns this property. Is it merely the compilation, which is property of the debtor, or is the actual information about people's health and their habits property of the estate as well, which can be sold free and clear of other interests? And are these privacy agreements interests which these assets can be sold free and clear of? Are these privacy agreements executory contracts which can be rejected
or they no longer executory contracts because the people who provide the information that performed anything they would ever perform.
That's a great valuation.
Well,
What's the damage?
What's your take on that, Paul?
Well, one additional issue is there is when Ken was showing us the site, there is a trustee seal. And trustee is a third party that comes in and says, we will audit what you do with the information. And so they have a contract of some kind, not only with the people whose information is being collected, but they have a contract or an agreement with trustee, where trustee will hold their feet to the fire. Then the other issue is that even if they are bought by a company...
But Planet RX in the same business.
Absolutely, and generally, if you're bought out by a company, all bets are off, and there's a movement in the law, but let me tell you about policy too, the movement in the law is if DoubleClick buys Abacus, DoubleClick is an online database ad server, and if they buy an offline database collection, the law says they own both collections of information. But we've seen recently great public pressure being placed on DoubleClick when it said it was going to combine the offline and online collections, even though it owned it. So the first issue is trustee. What would trustee do? What kind of agreement did they have with trustee, this third party? And then this other issue that even if they do have a contract, and that contract is, as it were, bought out by whoever buys this asset in bankruptcy, there may be a lot of public policy.
Is it possible that in the hands of the existing debtor, the information that it collects and is promised not to use has one value, but if sold, can be used differently and has a different value?
Absolutely.
Neil, how do you secure your lien in that list?
Well, how do you secure your lien in any of this? Is really,
Okay.
I mean, obviously, that's an even harder question. Because people tend to think that making sure you have a security interest that's good in bankruptcy is easy and old hat. After all, we've had Article 9 for 40 years. But 40 years ago, we got Article 9, we didn't have dot-coms, we didn't have new assets, and it's not so easy. I was looking at the list of types of assets that Yahoo has, the customer lists and everything else, and most of them, I suppose, under current Article 9, would fit into the category called general intangibles. It would fit into that because the definition of general intangibles is if it's not anything else, it's a general intangible. And most of these things weren't heard of, so they must be general intangibles. But that's where the easy part stops. Because for any of this property, the first thing you've got to ask is which law governs. Article 9, which we always think of for security interests, is of course state law. When federal law comes in, and now I'm not talking about bankruptcy law, but federal intellectual property law, like copyright law for some of these materials, perhaps trademark law, federal law trumps when it's inconsistent with state law under the Supremacy Clause. Plus, Article 9, the state law sometimes defers to federal law to figure out how to perfect. So the first thing...
That was clear.
That was very clear, right? That's why this is so easy and why it's so much fun. So the first thing you've got to figure out is which law governs how you perfect. You start off with Article 9. And by the way, as part of this question, we have to decide what today's date is, because as those of you who've been following these things know, there's going to be an all-new Article 9 in less than 18 months that changes the answer to many of these. Let's stick with old Article 9 for a moment. You've got to decide what the answer would be under old Article 9, where we've got general intangibles most likely, and if Article 9 governed, you figure out where you file a financing statement with respect to general intangibles, which means you've got to figure out where the debtor is located. The debtor is located where its chief executive office is. That's really easy for a factory. You can figure out where a factory's chief executive office is. But Yahoo maybe run out of someone's bedroom, and you can't tell which bedroom and which state it's in. And when there's three people involved and they move around a lot, you may not have any idea of where you're dealing with, which is a key issue right off the bat. To the extent the collateral is copyrightable material. Gets harder because the Copyright Act tells you how you record interests in copyrights. Judge Kaczynski decided that has an interesting relationship with the UCC, so interesting that you have to record security interests in copyrightable material in the copyright registers, which is great if it's a registered copyright. It's a lot harder if it's not registered, but he didn't seem to focus on that issue. Every issue you can possibly imagine, just on these basic issues of how you perfect.
You know, how many copyrights are there in a website?
That's a good question, because now, I'm not a copyright expert, but correct me when I'm wrong, but each published item could be a separate copyrightable item, couldn't it?
In fact, it doesn't have to be a published item. It's any item that is written down in the tangible medium of expression. So that might be the English language, it might be the images, design images, it might be the HTML code or the Java code. It could be any number of tangible expressions on the site.
So if you want to protect your interest in the rights in a website, whatever we want to call them loosely, is each page, is each image a separate copyrightable item, in which case if you follow Peregrine, you're spending nothing but filing fees all day long?
Well, that would depend to some extent how the website was distributed and whether the pieces of it were distributed as a separate work or not, published as a separate work.
But Yahoo is constantly updating those pages, adding information, taking it away, adding new graphics.
And it's unlikely they're filing any of this with the Library of Congress, right?
That's right. In fact, most companies don't file anything because you have protection for data creation, and there's only certain reasons why you file the certain protections you get, but not truly the copyright.
So how do you gurus advise a lender as to how he perfects his security interest in collateral? For example.
And maybe not to put a whole lot of reliance on security interest in the copyrights, because depending on whether Peregrine is followed, especially with respect to copyrights that haven't been registered, you may not be able to say with any certainty you have a perfected security.
You know, there's another asset that runs hand in hand with that. That's the cookie that they put in your computer. For those of you who don't know what that is, the site, when you hook up to the site, they put something on your hard drive, which has various purposes.
They will place cookies on so they can serve up banner ads. And so there is sharing of these cookies.
Now, one of the reasons that
they're in my computer now. Amazon.com, $100 million every time we look at it, so that they finally go. They have a wonderful list on me of all the books I've bought, everything else, which they use all the time. They have a cookie in my computer. Now, the list is one item.
is under FTC scrutiny is because they've placed cookies on the computers of the public without telling them that they had done that and without letting them know that they have the ability to turn the cookies off in their browser and not accept the cookie.
Max has a question. Max wants to know if he now is under the impression that he can't use and maximize the value of any of this private information that he's accumulated because he has certain contractual constraints. If he files, can he turn that into a more valuable asset in the company itself now and free himself to be able to sell that information where he would otherwise be constrained to? In other words, can he get a bankruptcy court to give him an order that says these executory contracts or whatever else they are that has restrained him from using this information no longer would restrain a reorganized debtor, and what was $25 million of value became $250 million of value?
Well, what bothered me about that when I saw it is that you are changing, to a certain extent, you're changing the contract. So we had a piece of real estate with a lease on.
Contract?
Oh,
Just
just
I
being
have
pursued.
a question I'd like to ask the students, which is this an executory contract that's even capable of being rejected? Now, Ted, you want to back up and explain what the arrangement is here?
Okay, let's go back to, let me bring back the privacy arrangement.
The privacy arrangement.
Okay, the privacy arrangement was they collected personal information about, here it comes, one more slide.
You give us personal information.
So that we can provide you with customized supplement plans. So it's medical-like information, but the information is provided subject to an agreement which says we'll never share it.
Right, so
now, mind you, students, you gave the information to to us, and that was the only obligation that you had, and we then said, we'll tell you whatever we tell you after the fact, but we will also take on this continuing obligation to not share your data. Is that an executory contract?
Never, never, never.
Never, never, never.
Well, under the countryman definition, I don't think it would be an executory contract because after I've given you my information, I have no further obligations.
So the question, and this is so that
Sylvia is shaking her head, yes. I think she agrees.
I partially agree in that I don't agree. I agree with Heidi that there's nothing else. There's nothing else that need to be done here unless we look at each transaction as a separate contract. And if we do, then the next time I give you information, do we look at that as a transaction and I am now giving every single instance of giving you?
There's no obligation, but is there ever a continuing obligation on both sides when that transaction is completed? They have more private information and you have your supplements, but they have their continuing obligation. You, in that situation, have no further obligation.
I don't think it's executive.
In fact, the way it normally works is when someone logs onto a website the first time, there's a little screen that pops up with what's called a web wrap or a click wrap, which are all the terms and conditions, which most of us don't look at. Most Devin and I, they look at that. You scroll through it, but you click I agree. When you do, hidden in there somewhere is probably all this privacy information where you're saying I agree. You can collect my privacy information and what you can and cannot do with it. So there's only once you
One
click
of the
on
things they said they would not do is disclose it to anyone else.
Well, in reality,
I have a quick question for Paul, which is outside of bankruptcy. Are you aware of any situations where courts have enjoined sales of private information based on a web-based privacy policy?
No, but that's in part because what most sites will not do is make the promise we will never, never do this. And what they will do is they will say, we will share our information with well-chosen companies whose offers you will be interested in receiving. They will also say, we also reserve the right to change any promises that we make.
That's my favorite. We'll never, never do it because it's subject to change.
Come back to the issue. Is this a contract? What do you think? Scott, you have a creditors committee here, and this is the only asset. Is this a contract? How do you pack it?
The answer is, I agree with Heike that if it were a contract, it seems to be fully executed and is non-executory on both sides. And so, what are the consequences flowing from that? More of an answer.
Is it a contract?
Well, I think it is a contract.
It's an executed contract.
Executed contract.
Partially executed contract.
It's an executory.
It's not privileged information because you haven't got a physician or an RN or anything like that on the other end of it.
It's solely an asset. Well, that's solely a claim.
No, it's an asset.
The information is an asset, but the use of the information may give rise to a claim. And then the question is, what's the status of that claim in the bankruptcy?
What is that? What claim?
Well, you have no damages. You may have no damages. What would a court do if your bankruptcy court told there's this claim with no damages associated to it? Is it dischargeable?
Well, we want to back up a second. To say that it's not an executory contract is not to say that it's not a contract. There is a promise here, right? And the promise is enforceable.
You have to prove in each case that they only gave the information in reliance on the promise, so that if you have 250,000 people who gave it to you, you have to prove each one separately.
It's supported by consideration.
I'm telling you, Judge, that there
are
250,000 customers standing on the courthouse steps who have heard that this information is going to be sold. And they want to enforce that promise, not to sell.
Yeah, but what rights do they have?
Well, the question... Why isn't this, why isn't this a misrepresentation of a material fact with intent to deceive on which they reasonably rely and suffer damage?
Because it wasn't at the time.
Because it's... Wait.
It has to be at the time that it happened.
Yeah, but if they gave the judge, if they gave the promise, Judge, if they gave the promise at the time they had this lien and had this asset leaned up, isn't that a breach of the promise right away, knowing that it's false? I'm not going to share it with anybody, but yet I'm giving a lender a lien on it?
But isn't the only question who the we is? When it says we will not, who's the we? Is the successor of the we?
Well,
You make this slap acid distinction, I don't think you have to go that far.
well, the question is, does it bind the bondholders? Does it bind a new equity that comes in? That's the issue.
Are we assuming the bondholders have a lien or don't have a lien? Valid,
Assume for the moment they have valid.
Assume that they certainly have a contract that doesn't have a lien on everything.
If you assume the bondholders have a valid enforceable,
How do you do that?
and you do what? Perfect it, have a lien. They have a
Wait a second. Validity means perfection or something. How do you perfect it?
You lend more and you get a roll-up from the bankruptcy court.
Okay, but he's talking about going in. It says you can have a lien, you may have a lien on the proceeds of the sale.
Why can't you have a lien on customers?
How do you perfect? You take a list and put it.
I go to my lending colleagues and
You perfected interest in customers.
Well, that's the nice thing about the definition of a general intangible. If it's property, it's something, and it can be a general intangible, but is it property? Something that other law says you can't transfer, that you can't dispose of, is that property? That's come up in a number of contexts, ranging from liquor licenses to non-transferable licenses, which is another issue.
Neil, forget the issue of whether there's a restriction on being able to dispose of it. Forget that. Is a customer list without that restriction something you can perfect a lien on?
Sure.
Okay, so the answer is yes. And the answer is that if the bondholders can't perfect a lien in the customer list, this reorganization revolves around the value of the customer list.
Just because you can perfect a lien doesn't mean it has value and that you can do anything. Your lien may only get you into the debtor's shoes. Good for you.
Well, but this business is the customer list.
Well, it may or may not be. You've got an asset which may be tied to a claim. And the question is whether the claim is one that can be either enforceable by damages, which reduces its value, or use if it can be enjoined.
Like the liability, and they knew or should have known, they took a lien on the property, there was a promise being made by their debtor, not to share the information. I don't see why the senior lenders can't foreclose in this collateral and sell it.
Well, we
And if there's more value than senior secured credit owed, there'll be excess value to the unsecured credit.
But you know, isn't it something like whether or not you can get any value from it, which means you're right in the shoes of the debtor, whether you can foreclose or not, and you're still left with the question, sounds to me like this is not so much of a money damages claim as a claim, an equitable claim, and you got 5,000, but people are going to hire a lawyer and go into bankruptcy court saying we won, and
They don't have to hire a lawyer.
and you're back out to the state law. State law is going to determine whether or not that injunction will issue.
Well, why again did you file this bankruptcy?
Well, no, it's becoming more interesting because when we start the equation, the assets, we're looking at a certain defined assets. As we get into it, we're saying an asset that would otherwise be in a sense locked up in this private information I've collected may, in the context of a bankruptcy, have value that it doesn't have anyplace else. Because can the reorganized debtor or the prospective reorganized debtor or its bondholders or the IP financier walk into court and say, you're absolutely right, this asset as between the debtor and its clients was private information. I have a security interest in it. I essentially want to take it free and clear of any of that, and it has tremendous value. So what I want the court to do is strip away this baloney of privacy and allow me now to do what I want with this information. What does the court do? Is it's faced now with a legal issue, and it's faced with an enormous policy issue.
Isn't part of what the court does is to say no more metaphors, and let's figure out what it really is, as opposed to saying there's this big thing and we're going to strip away some limitation. If you loan money to the coat check room at the test, secured by all their flows, you don't get to sell all the customers per post. They don't have the right to sell. It's just being a different metaphor, right?
Property of
But is the information the property of Yachu, or is Yachu sort of a bailee of this information because of the promise it made simply to have this information in order to serve its customers, not to be able to use it for any other reason, just like the code check says, well, we'll do
How
it.
many folks think it's fair that the only person who has a shot at knowing the answer to this question is asking?
Well, does it make it easier if I say I don't know either?
Isn't one of the easy answers your suggestion, to focus on the difference between stock and assets? It seems to me, who owns the stock of the company would be irrelevant to the people who supply the data, to the website.
Remember, this data has value not because of what it is, but because of what can be done with it, which means that what information advertising can be distributed to these individuals.
Right, and it sort of reminds me of NOL in the old days. I mean, I'm a bus with NOLs, and you merge with a company that's got an ongoing business and utilize NOL. I'm a bus company, I merge with a company
Well, that's why I used that example before. Assuming the buyer is someone like Planet RX, which does more than vitamins and coke, they do prescription drugs, they're far beyond this business. But they're now the owner, they're now Yachu. It's called Yachu, Planet Yachu.
I think what probably happens is that when the 5,000 people come to the court and ask for this, in
250,000,
and you have this deal where Planet wants to take over, and there will be a change in the ownership, so you do have this issue to face. Planet is going to say, we will abide by the exact same rules. We'll use it in the exact same way that Yachu was going to use it. Hopefully that's the way the judge tonight should be.
In a practical answer.
That means the only one that can buy it is someone who's in it.
Well, the practical, it's not what wants to be Yachu. It's not quite that extreme.
And there's a value issue. You just,
That's right.
It's just drop the value.
That's right.
The privacy policy, as broad as it is, never says that Yachu won't change its business. It says we won't give it away to someone else. And if in fact Yachu changes its business, as these companies seem to do every 3 or 4 months, that seems to be perfectly consistent with the privacy policy. And one of the threshold issues I think we started with is, do these companies reorganize, do they liquidate? But if to the extent that there were serious issues about whether you can sell this, whether it's a property right, a contract right, or whatever, versus can you put more money in and really maximize the value of these assets, that suggests that these companies, in fact, may have a reason to file for Chapter 11 beyond the immediate need for the automatic stay in order to maximize the value of the assets. One of the basic tenets of why any company would file for Chapter 11 protection.
Your assumption is that these companies out of bankruptcy didn't be sold. Your assumption seems to be that if these were healthy companies, the owners couldn't sell the businesses and someone violate this privacy.
I faced this issue recently in a situation where Party A had a valuable domain name, and in conjunction with that domain had collected a lot of information about consumers. Party B wanted to buy the domain name and the database. We took one look at the privacy policy of our client, Party A, and said that wouldn't be a good idea because it was something that wasn't as strong, but it probably wouldn't be a good idea. This doesn't say that you can't use it for particular purposes. So in the situation where we faced, we ended up structuring the deal so that the domain name was transferred, but there was an agreement that took effect, which said that Party B, that was paying the dollars for the domain, would have the right to go ahead and broadcast marketing campaign and advertising information, would give that information to Party A and let Party A distribute the information. So again, it was Party A, the asset still existing and the ownership still existing in Party A, but the value, it was almost like you would have to treat it as a black box with information in it, and the agreement said that Party A could just channel information into the black box and out to the consumers, and that way the privacy policy was not violated.
But you can get that. You can get where you want to go.
And one of the reasons
that's one possible solution.
Theoretically, you can.
And one of the reasons you do that is non-bankruptcy reason as well is, just in Cayman here, you have international considerations here. E-commerce is global. And so we're just thinking U.S. law, but a lot of these sites are global. And you have, in Europe, you have the EU, and they have the EU directive on privacy, which is much more stringent than it was here on privacy concerns. So we have to think about those concerns as well, on restriction on using the data outside of particular jurisdictions or agencies.
I think it's clear there's going to be a lot of judgment law here, because Congress is not going to react to any of this, because they don't understand it any better than we do.
By the way, Congress has reacted in certain segments. That's the other issue. For instance, children's information.
Right.
If today was April 22nd, I would tell you yesterday, April 21st is when the Children's Online Privacy Act went into effect, which governs what information can be collected from children under 12 without parental consent and so on and so forth.
Would the intellectual property gurus advise his client to patent his business plan?
Well, there may be methods of doing business that are undertaken by this company, which might be unique and novel and non-obvious. And we always say, based on the State Street Bank and some other decisions that have come down, that there may be methodologies here that are indeed patentable. And probably this company, like every other .com, has 3 or 4 patents, applications on file. Those patent applications are confidential until the time of patent issues. So until that's disclosed or some kind of non-disclosure, there wouldn't be publicly available information.
Let me ask you a question, because I represent a bunch of venture capitalists whose heads are spinning right now. They need to keep this company alive. They have poured, notwithstanding what the bondholders have put in, my clients have poured in a ton of equity into this company over the last couple of years. We want to put in some money to keep the company alive. How do I do that? Who do I talk to?
Pay the interest on the bonds and you can do it.
Except for the thing.
Sure. The business reality, for better or worse, is that this is such a fast-moving, fast-changing market that from the DC perspective, we go through this business every day and know that the flow of capital, the companies that are out of favor, turns off like that. And your image in the marketplace is almost everything, and any taint of trouble, the talent runs, the money is gone, you can't raise new money, and you have 2 months left on your last round, you're in big trouble. And I think what really happens is you start looking for that merger or acquisition, and the BC is going to push for that as early on as possible. So you have the disjoint between the inherent problems of bankruptcy and the realities of this market.
If you really want to put money in the wise outfit, then who are you now? You're a venture capitalist.
Venture capital.
Then just buy the bond.
Yeah. And the second choice is...
Just buy the bonds, offer them a discount, you're in control of holding?
No, he's not. What happened to our licensor problem?
Well, I was just...
He's financing himself.
As the last issue, let me ask the debtors' lawyers here, Neil and Herb, you have a license, what? You have a license, but the license, it's a license to use WebPay stuff, and it's a license to embed WebPay's software into your software when you sell it as a package to other businesses. First of all, can you assume it, you sign it?
I'm going to say that I've got to assume that it's not just for my sake, Judge, but because I've embedded that.
Make this argument.
I've embedded that software in not only Yahoo.com, my own site, but sites that I've built for other people that rely upon me, so that if I'm not able to do something with this, you're not only affecting the ability of my business to go forward, you may actually be triggering a domino effect. So I've got to do something here to keep that license alive.
Why?
Yeah, but the question is, what authority does the court have? What power does the court have to allow you to do that? If
Don't say 105.
I'll say it when I represent the debtor, but frankly, if under applicable non-bankruptcy law, it's not assignable, then you're going to have a problem trying to assume it and assign it, or just assume it in the bankruptcy case.
You're going to
have to stay for a time until you can find someone who's going to...
I agree.
People in the case.
Until you get to the point of seeking an order authorizing assumption, it's sort of been eliminated.
Ted, would you bring section 365F1 up?
I would love to.
And this may be one of those assets, the value of which we can enhance by...
F1 or C1?
Let's go to F1
Okay.
first, because I think we can deal with, is that Herb's issue? The problem that we have is that these licenses are non-assignable by their terms. But section 365F1 seems to make those non-assignability provisions not enforceable.
Yeah, but that's a provision of the agreement. I'm talking about applicable non-bankruptcy law.
So you mean section 365F1 may not apply?
Precisely.
Okay.
Well, what about whether, could you, if it's non-assignable under applicable non-bankruptcy law, is it assumable?
Depends what circuit you're in, not go. Until there's a revision to the section, it seems that most of the appellate courts have held, I think the First Circuit goes the other way, but most of the appellate courts have held that if it's non-assignable under applicable non-bankruptcy law, it's not assumable in bankruptcy because of the distinction between debtor and debtor in possession and the hypothetical test that was laid down in the Catapult case.
Even having read some of those cases, it's a tough argument to make that the purpose of Chapter 11 is to reorganize, and I read those cases also, and that you can reorganize, but you can't have your contracts.
Take it back to section
And all of your brethren have held the same way.
For those who...
The appellate court.
Let's slow down for a second, because this got technical really fast, and not everyone's familiar with the Everett's Catapult and Institute Pasteur cases.
For those who haven't read the opinions, are actually taking a good hard look at section 365C1 for the students, since it's going to be on the exam. Take a look at subsection C1, which creates an exception to the general rule in section 365F1 that non-assignment provisions are not enforceable. That non-assignment provisions are not enforceable in bankruptcy. Section 365C1, at least as the courts have construed it, seems to say that notwithstanding section 365F1, if governing non-bankruptcy law, irrespective of what the contract says, would not permit assignment of the contract in the absence of the consent of the non-bankruptcy party, the contract may not be, according to section 365C1A,
assumed
or assigned in bankruptcy. Now, do we have a slide that shows this statute as it was originally written? We do. Cool. When the code was, the version of the section that appeared in the code as originally enacted said, you can see better than I can.
It said applicable law, if applicable law excuses a party other than the debtor to such contract or lease from accepting performance from or rendering performance to the trustee or an assignee of such contract or lease.
In other words, the statute provided that if governing non-bankruptcy law excused the non-debtor party from accepting performance from or rendering it to a trustee, irrespective of what the agreement said, then the license or the contract was not assumable or assignable. And if you think about it, that makes sense. The classic example of this section in action is the contract with Picasso to paint your portrait. Picasso files a Chapter 7 petition. A trustee is appointed. You don't want that trustee. Well, I guess it depends on the trustee, but you probably don't want that trustee to paint your portrait. And accordingly, the contract is not assumable nor assignable by the trustee. But there was some confusion, apparently, about the meaning of Section 365C1. So in 1984, and I think again in 1986, it was amended to provide that the contract will not be assignable if applicable law excuses a party, that is the party other than the debtor, from accepting performance from or rendering performance to a an entity other than the debtor or the debtor in possession. And
It was the addition of the debtor in possession language
that has resulted in something quite strange, and probably at odds with what the drafters intended. Because we think what the drafters intended was, by the change, to make it possible and make it clear that if, for example, Picasso filed a Chapter 11 petition and he wished to assume the contract of paint your portrait, he could. And that makes perfect sense. You don't care whether Picasso is in or out of Chapter 11. It's still Picasso. However, if you read the statute at face value, what it seems to say is that if applicable non-bankruptcy law excuses a party from rendering performance to or accepting performance from a debtor or a debtor in possession, then the contract cannot be assumed or assigned.
So what is the
just 1 second here. The point was to make that contract non-assumable, non-assignable.
But they ended up making it,
They ended up making it neither assumable nor assignable. And that's the problem. And in the Ninth Circuit and several other circuits have held that even a debtor in possession cannot assume a contract or a license that under applicable non-bankruptcy law cannot be assigned.
So, but that,
for example, a patent license.
So, understanding a couple of circuit cases, it's not just in the license area, it also involves partnership agreements. And the partnership cases are split in the country. In the Fifth Circuit, there are problems in the Phillips case, but in several other cases in California, or also in Pennsylvania, with limited partnerships, you can assume it as long as you don't assign it in Chapter 11.
Now, the good news is that this nasty little problem may be solved by the amendments to the Bankruptcy Code if the House version is adopted, although there's not such a provision in the Senate version. So it'll be interesting to see what comes out of conferees. If it doesn't emerge in the final bill, then it means that these licenses may be worth far less to debtors than they might appear to be, at least in the circuits that apply Section 365C1.
Maybe it's more fast conversions.
Well, what position does this put Oracle in a high-tech bankruptcy where Oracle owns a license to the debtor's inventory software? It basically means Oracle can pull the plug because Oracle, they may not even be able to use their own inventory software to run the company once they file.
And I have a question for Neil, which is what is Section 365C1 or? Actually, I should ask it another way. What is the non-assignability provision in that license due to the debtor's ability to grant a security interest in that license?
Well, this is another one of those questions that depends on when we ask it, because current law may be different than the law 18 months from now. It's very common in software licenses to say this is a non-exclusive, non-assignable license. Does that mean you can't borrow against it? You can't use it as collateral to make a loan available or make it available in better terms? On face value, it would seem that the answer is yes, because the software people vigorously enforce those licenses. If they've been terminated because of a breach of the contract, then the collateral is not worth much. Now, that's inconsistent with the general notion in American law of that free alienability of property, even partial property interests, like the interest as a licensee. And that's been the source of a big debate between financing interests and software interests over the last several years. Revised Article 9, which goes into effect next year, which is why I made the reference to 18 months, tries to resolve this. It sort of steers a compromise path. And Revised Article 9 takes the position that the mere granting of a security interest, a granting or perfection of the security interest, cannot constitute an event of default under a license that has such a non-assignability provision in it. But notice how far it went and no farther. It's the granting and perfection cannot constitute an event of default and do not give rise to a termination.
But what difference does it make? What difference does it make? What lender is going to lend take a security interest and not be able to do anything with the collateral.
Well, that's exactly the issue. If it's the license for Windows 98, which you and I share with 250 million other issuers, and Microsoft is not going to let us resell it to anyone else or not allow a bankruptcy trustee to resell it, it means it's worthless. On the other hand, for custom design software, perhaps the web page software here, if it was custom designed and it's not a non-exclusive license, if it was an exclusive license, it's possible that what this would give us is at least the ability not to sell it. The secured party wouldn't be able to enforce it directly, but to have the first cut of the proceeds if in fact it's resold. It partly depends on the nature of the license. Still, the software licensors have the upper hand here, given the compromise in Article 9, but it's not quite the complete total controlling hand as under current law.
Why are we not seeing traditional lenders in this field? Michael, we have about 1 minute, and I'm going to give you the last word since you have about 100 hours in this project.
Well, I'll tell you, something that you said tonight has really been bothering me. I'll ask the question in a minute, because it will be on the exam. But before I ask the question, I want to thank everybody who came tonight, who participated tonight, and also the members of the steering committee who worked so hard to make tonight work. But my question is this: if that cookie on my computer belongs to the debtor, and I wipe that cookie out, what's the question, students? Have I violated the Senate? And I should ask whether there are any other questions for any members of the panel.
By the way, civil disobedience is easy because if anybody types in, goes to find, types in cookies.txt, you can see all your cookies on your hard drive. Go home and do it if you want. That can be the assignment for the students. And if there are any cookies there you don't like, you have a right, it's like civil disobedience, to leave them away.
Unless they're in bankruptcy, in which case you violated the automatic stay.
I'd like to just ask one last question, if the chat out answer. Do we think if we file this case, it'll last longer than the first day? What's the consensus? Does a case like this last so that you can get these issues and hopefully stay alive for the judge?
This case is only good for the judge made law.
I think this case stays alive.
If it's advisable for us,
Who puts up the money, Judge?
Do you file it? Myron, do you file it?
You agree, you have to negotiate this before.
I think Ellen's position, you file as a last resort.
Obviously you file as a last resort, or you file as a...
That means that the judge has got to be exceeding aggressive on the first.
Judge, you need financing. You need the financing. The only case that works is when you have a sale lined up beforehand and you go in to sell and you use the bankruptcy processes, which is remarkably effective for that purpose. But any type of, anything that even smells like a pre-fall case is finished.
Who's your client, right?
Max.
He's got a fiduciary duty to preserve the assets from me, and he's getting nothing. I think, is he fine?
You have to come back next year. Thank you.